So, you know, the reason that I do this, now I'm recording it, is because I want, you know, like it sucks. It's hard. The bar exam is really hard. It's really hard, but it's totally figure outable. You can figure it out. You can absolutely do it. And like one of the things I love is when people have those aha moments, like, oh, you know, that's how I do that, or this is how I do that thing, or, you know, this is just when you have a process or a method. So that's really what I spend a lot of my time trying to figure out, is those methods. And a lot of it's based on research too. How do people learn? How do different people learn? Engaging in formative assessment. So working with students to figure out, all right, you know, what's Lisa doing well and what's Lisa not doing well? And based on, you know, how she, like what, based on the things that she is picking up, how do I need to modify what we're doing, or, you know, create something to deliver the information in a different way. Because if there's, you know, whatever way Lisa learns might be the same for, you know, a lot of other people, and, you know, compared to Jordan or Bernadette or whoever it is, you know, people learn all these different ways. So we really try to be adaptive to students on a broad scale, and also be available and provide, you know, individualized, tailored feedback. That's really the big thing. That is like one of the biggest things when people are repeating. You want to make sure you're not making the same mistakes. So it's really kind of figuring out what those things are. And once you figure it out, usually the student can apply it broadly and make some big improvements. So it's really fun. So that's sort of just a little bit about me. What else? So we're going to talk about the PT tonight. We're going to really talk about, I did one of these before. So I did another workshop where I really go into the basics of all of the stuff, figuring out the PT. And I'm going to review a bit of that tonight, or it'll be the same process rather. But the other PT that I did was a persuasive performance test. It was Haynes v. National Bank of Columbia, or Haynes v. NBC. So people from that workshop requested that I do one that was objective. So that's why I selected just one of the more recent performance tests that is an objective one. So that's why I'm doing this one tonight, was because people just specifically requested that. And I'm like, well, not really doing anything on a Sunday night anyway, since can't really leave the house very much. So figured I might as well do this. So here we are. All right. So first thing I'm going to share my screen. Just share. Okay. So today, let me move my little boxes. Also, if you guys can just refrain on questions, unless it's like something, you know, whatever, like if you like have to have an answer to right now. I'm going to look at questions and answer questions at the end, just because it's so, oh gosh, I just spilled my tea all over my planner. That's fun. If you can wait, just to, you know, hold off until the end, I would appreciate that. And I'll go through and I'll answer questions. And I'll also talk about, I'm doing, let's see, I'm doing a course too, which I'll talk about. I know some of you guys are signed up for it actually already. And the course goes a lot more in depth into PT. So I'll talk about that a little bit at the end as well. But first, I want to talk about, you know, really in order to, Kimberly, I've sent it to you a few times. I wonder if I have the wrong email address.
Yeah,
but if somebody could.
I don't know. That's my email address though.
Let me see. Hold on, I'm gonna send these so that we can try to get people that are missing them. Or if somebody else can send these, I would appreciate it. But let's see. And Kim, you know that I'm doing one at Southwestern on Tuesday, right?
Yeah, I think we just got the email today though, so I.
Oh yeah, I think that sounds right. And then. Okay. Chris, I got you. Leon, I sent them to you. You guys might want to check your junk mail.
I checked my junk mail too. That's why.
Oh, that's so weird. Hold on. I'm just gonna. AGW. Sorry, I'm sending them from a different email. Oh yeah, you can also find it there. Thanks, Cher. Good call. It's posted publicly. The only reason for having it in here. Okay, cool. All right, good. All right, so one of the big things in understanding a PT, and like really with anything, any component of the bar, is getting kind of in the mind of the grader, understanding, or the grader, the writer of it. Because when you understand how it was put together, you understand how to respond to it. So, and this is why like there's this thing called Bloom's taxonomy of learning, where the people that, if you really have mastered something, you can usually write a problem based on it. So like you could draft your own hypos that are complicated and nuanced, and that actually demonstrates that you really understand a topic or a subject. So we want to, you know, that's the goal, is to help you guys understand how these are written. And then how do you structure an objective performance test, and how do you complete it also without printed copies of the materials? You guys all know, which we didn't know last time I did this, which I think it was 2 weeks ago, that you will actually have scratch paper for the performance test. You'll have 8 pages of it, but which is great. And so some of this you'll be able to do by sketching, you know, or just not sketching, like by sketching it out on scratch paper. But you don't have a printed copy of the materials, obviously, and I think that's really what makes it challenging, but you can highlight it. So I'll incorporate a couple of additional strategies for highlighting, etc., and you'll have different colors as well. So I'll highlight, you know, what to do with the highlighters when we go over this tonight. So how do you complete it? And it's really particularly the thing that I'm going to focus on. The thing that I will really focus on is, how do you figure out the organizational piece? How do you figure out the organizational piece? So, you know, that's usually, in my years of teaching and teaching the PT in particular, that's where people really get caught up. And that's a lot of people, you know, run out of time. And the reason they run out of time isn't because they can't apply the facts of the law. It's figuring out, you know, what is all the law that I need to have? What are the cases here for? What am I supposed to do with this particular case? So that's really what I'm going to focus on tonight. And then how do you organize the materials? How do you use the library so that you can then write your performance test? And essentially, yeah, so that's basically it. So I'm going to go over, so the process for writing performance tests. So the first thing you're going to do is you're going to review the task memo. That's about 5 minutes, and you all should know that, or I'm assuming that you all know that. That's the first thing you do. The task memo is the most important document, and it gives you the most important facts. So it's really going to just give you a general understanding of what's going on, or hopefully it will. I know for the February 2020 PT, people were still just confused because that was like substantively, it was a tough performance test, I think. Then you're going to set up your PT outline, and I'll go over this. So you're going to set up your, give it your heading, if you have one, and then write your introduction and your conclusion, and include your macro headings, which I'll show you what those are. If a document is mentioned that you think will provide you with your organizing principles, you want to read that next. So if there's something that's provided that's going to tell you, you know, if there's something that's going to tell you, for example, what that you're, you know, if you're responding to a motion, you're usually going to use the headings from that motion, and you're just going to draft yours based on that. If you get a letter and you're supposed to respond point by point to the letter, then you're going to go and read that letter first. Otherwise, you just skim the file, and I'll show you what a proper skim looks like. I'll go over this. I did it in the last workshop, but like, it's important that every single time you do a PT that you follow the same process, and that way it's just like second nature especially on test day. And then after that, I want you to skim and read the library. So we're going to be skimming the library and going back from skimming it. You skim parts of it and then you start reading it. I'll talk about that, but you really want to read each case with a very particular purpose, and particular within how does it go to answering the questions that you were given in the task memo, right? If your task memo tells you we want to identify these 2 things, right? So like the one we're going to deal with tonight deals with evidence, and it says, you know, we're dealing with, I think it's 404 and 608, but character evidence and impeachment. Say, okay, does this case talk about character evidence and the rules, and, you know, when you can admit it for its substance? Or does it talk about impeachment or does it talk about both? And which way does it come out? So I know whether I'm going to analogize to it or distinguish from it. So you really want to read each case with a purpose. And really what the cases in the library do, so for all of the cases, you're going to be using them and you're going to be writing about them to some extent, obviously, when you're drafting your answer. So you have to understand, really what is that case there for? What is the substance of the case? What is it discussing? And so we'll talk about that. Because you have to draft a case explanation, or I call it a rule proof. So do you guys all remember first year legal writing? Okay, so did you guys use like ERIAC, CREAC? I use CURPAC. You all know what, so I'm using that terminology, and you know what I'm talking about. I know at West there's like BARIAC, and there's just like all these different ones, but it's essentially issue, rule explanation, rule proof, case explanation, whatever term you want to use there, analysis, counter argument, and conclusion. Those are all separate paragraphs. It's rule. I need to count these. Analysis. So there's like 4 or 5 paragraphs, depending if you have a counter argument or not. So you have. So you're going to do that for each issue, right? You won't have necessarily a rule proof or a case explanation for every issue, and I'll talk to you about that. But you have to understand for, which issues are you going to have that. And so we'll talk about that. I go into that quite a bit in the last workshop that I did that's posted to YouTube. So you want to focus on the analysis of each of the cases, and then you want to assign cases. You're going to have a skeletal outline that you're drafting, and you want to assign the cases to their appropriate issues and identify where you're going to draft rule explanations. And I just use these terms interchangeably. I like rule proof, or you can say it's a rule explanation or a case explanation. And then you're actually going to go through and you're going to draft your rules and your rule proofs. Once you've gone through the library once, right, then you're going to go back and you're going to actually do the drafting of your rules and your rule proofs. Even if you see a rule and you're like, yep, that's the rule, I don't want you typing it in yet, because there might be another case that changes the rule or adds to it or does something. So you go through the whole library and then we go back and we draft. And I give you a formula here that makes it really simple to draft your rule proofs. So you just say in case name. Oh, there should be a little comma there. Shame on me for having a typo. I teach legal writing too. So in case name, the court held, what was the holding regarding the narrow issue that you're dealing with, because facts and reasoning. Sorry, this should say read file. So then after you're done, so the whole point of this, or a big part, one of the points of this, of doing this, is so that you, so you read once you're done with the library, like you're done reading, you draft your rules and your rule proofs, then the library's over with. And then all you're dealing with is the file. By the time you get to this, you'll have about 45 minutes left. You should have all of your rules and your rule proofs and your introduction and your conclusion drafted, and I'll walk you through that within the first 45 minutes or so if you follow this process. You might not be there right away, but that's really, by the time you take the bar exam, and probably at least a few weeks before that, you should be there. So like come, what is it, October 5th and 6th now? So come like, September 10th, right around there, that's when you should be like solid writing PTs, being able to follow the time, being able to finish them and feeling comfortable. So then you're going to read the file. Once you read the file, then you're going to write your analysis. You're going to be comparing it to the cases that are in the library, and you give yourself a few minutes to proofread. Hopefully you'll have a few minutes to proofread. And then that's it. Then time. And time is critical on this particular test, as you all know. It will be given, you'll have just the PT. You won't be able to go back and forth. So because of that, you really do have to be on it with your timing. You've got to be on it with your timing. So let's see. So this is just, and it does vary a little bit from task to task, but the basic introduction, like the basic macro introduction, for all PTs is right here. So I use Roman numerals. So you have your introduction, you have your analysis or your argument section, and you have your conclusion. And you have your conclusion. So in the introduction, it's really simple. Most of mine are usually one sentence, and it's just regurgitating what the task memo tells you to do specifically. So I just do below, comma, please find my analysis of 1, 2. That's it. It's real straightforward, really simple. And because all you're doing is you're communicating to the reader. You're like, hey, I understood what I was supposed to do and I'm doing the right thing. That's it. That's all you're supposed to do. You want to make sure that you're writing in the correct tone. So if you're writing a memo, occasionally, but very rarely, they'll have you do a persuasive memo. But generally speaking, if you're writing a memo, it's objective. So just keep it objective. Then you have your analysis or your argument section. So you have to figure out what your headings are. That's the challenge, is figuring out, okay, well, what are all the points that I have to prove here? So you got to figure that out and make sure that you're following. I use whatever, CREAC, CURPAC, ERIAC. And then also identify where you're going to use the cases and the statutes that are given to you. And then third, you have the conclusion. So third, you have the conclusion. All you're doing is reiterating what you want or what you have figured out. Remember to keep your client's goal in mind, but have a canned conclusion. So I have a canned conclusion that I write for all of the different tasks I have. They vary slightly. But have a canned conclusion. So like you'll see what mine is for memos. Any questions so far?
Yeah, I had a question, Professor. Are we allowed to copy and paste from
No.
We're not? Oh, okay.
You can you can't from the fact pattern. No.
Oh, okay, gotcha.
Yeah,
okay.
yeah. Like in your response, like where you've written, you could like copy and paste something and like smooth a section around,
man.
right? But like, which I hate doing because it gives you that like alert, and it always gave me a heart attack when I did that in law school. But yeah, no, you cannot copy paste from. And so a couple of other things. So one, you should be doing a minimum of one PT a week. I prefer 2. I assign 1, but like PTs are my jam. Like I love the performance test because, so like just one little thing about like why these are so important and like why I'm doing an entire course on it is because the PT is worth 2 essays. You are going to get an essay. Like I will tell you this for sure. You are going to get an essay where you're just looking at it and you're like, what is this? Right? Like, so for those of you that have taken it, for people that took February, it was the BA essay, right? The BA essay was like, are these, so are these, the BA question said, are these people, is it a shareholder, a partner, a something and a something? There were 4 different things. And it was just sort of like, what is this? It was shocking. Mine, when I took the bar years ago, the question that I got, so everybody told us that we were not going to get a pure remedies question. They had just done pure remedies 3 times in a row. Essay number 1 was pure remedies. Like essay number 1 was pure remedies. And I was just like, I was so shocked. But I knew, I did have a little mini panic attack, but I knew that I could crush the PT that I was going to get that afternoon. So it helped. It helped me to like keep my sanity, to be honest. So there's that too. Or if you have other stuff, like if the MBE is a weakness, the PT can help you with that. So I would do 1 to 2 PTs a week, just so you've seen everything. And like I'm like my course, I'm going to go through like all the PTs and like all this stuff. I'll talk about that at the end now.
Question for you.
Yeah.
So is it going to be the PT just by itself? I mean, I thought it was going to be like 3 essays in the afternoon, 2 essays, and then the PT.
No,
so in the morning 2, because there's going to be 5 essays, right?
There's going to be 5 essays in 1 PT and then 100 MBEs. Yeah.
Yeah, but I mean, they're going to split up the MBE, 50 questions morning.
No, so here, let me explain the structure of how it's going to be. So what they're doing is they're not giving you all the questions at the same time. You get 1 question, 15 minutes. So day 1 is actually just the 5 questions. So it's question 1, 15-minute break, question 2, 15-minute break, question 3, break for lunch, question 4, 15-minute break, question 5, done for the day. After that, then day 2 is 50 MBEs, break, 50 MBEs, lunch, PT.
After the MBEs.
After the MBEs on day 2.
Makes sense. My other question is this going to be exam soft?
Yeah, it's exam soft.
Okay.
Yeah, but let's hold on like general questions. We'll hold off.
All right, sorry.
No, it's fine. It's fine. So, but yeah, generally, so the PT is, that's why I think it's so important. That's why I think it's just massively important. Yes. All right. All right, so let's get into this particular PT. So the first thing that you're gonna do, is you're gonna read the task memo. So you have about 5 minutes. You all should read the instructions at some point, but they don't really change. So after you read them once, that's fine. Just check. The most important one is instruction 2. This problem set in the fictional state of Colombia, one of the United States, and you know that there's 8 instructions. So if there are more than that, then you have to find out what's different. But other than that, you don't really need to read the instructions. So let me give you guys 5 minutes to read this. All right, that's about 5 minutes. So remember the most important facts are in here. I'm going to use one of my highlighters and I'm going to highlight, the more important stuff. What do I see from here? So we work for the ADA, so we're a prosecutor. and we have charged Ms. Martin with identity theft. So we charged her with identity theft. Martin acquired the name and social security number of another person from her former job at Fastcom, a cell phone company. And that just sounds really like you're not embezzlement, but you're entrusted with information and then you use it to carry out a crime, which isn't, obviously isn't great. Using this information, she tried to open charge accounts at several stores, in one case successfully. The person whose name and social security number Ms. Martin used discovered that use and put a fraud alert on her cards. The police eventually arrested Ms. Martin. I include a memorandum to file that summarizes the expected testimony on these points. So when you see a document that is mentioned, you often want to identify, or you want to go to that and actually look for that. So we might want to look at that document next. At yesterday's hearing, I gave notice that we intend to introduce evidence of 3 specific incidents involving Ms. Martin. So now I'm really curious as to what these are. We want to use all 3 of these incidents as similar acts evidence to rebut the defense that we expect Ms. Martin to offer. So we're using all 3 of the incidents. So I really want to know what these incidents are. And we know that they are summarized in the hearing. So I want to see, there's probably going to be a hearing transcript. I would like to admit them as substantive evidence under Columbia Rule of Evidence 404. So it's telling me that I'm dealing with Rule of Evidence 404. And generally speaking, if you see a rule of evidence, it's going to, or like a constitutional rule, it's generally going to match what the federal rules are, but not always. And like there's a specific one I can think of, Phoenix v. Biogenesis, that uses, that says we actually are not using the US Constitution for whatever reason. But here, and we'll want to look, but you can generally know that, that it's the same. Before I start briefing, I need an objective appraisal of the arguments for and against admission of this testimony. Generally speaking, so in this last paragraph is where you're going to get your task. You're going to be told what you need to do. And here, they will almost always tell you to include counter arguments. So here they tell you of the arguments for and against. You're writing objectively, but you need to raise and dismiss counter arguments. So please write a memorandum analyzing first whether we can admit any of these incidents as substantive evidence, and second, whether we can use them in impeaching Ms. Martin if she takes the stand. So here we want to know whether they can be admitted as substantive evidence. So it's not improper character, you're introducing it for some other purpose. And second, whether we can use them in impeaching. So you can offer it not for impeachment or not for the substance, but you can use it to impeach. So based on this, I want to do a quick setup. So then I'm going to go to, like, in my ExamSoft file, or in my, if you're a handwriter, you would actually go, well, if you're a handwriter, you're just going to sketch out a little skeletal outline. And handwriters, I know there's at least one here, and this is really for taking a virtual one, but you would just sketch some of this stuff out in your book before you go and start writing. And at the very end, I can give some tips for a handwriter. So what you want to do is do a quick little setup. So I'm going to turn off my highlighter. I do a little memorandum title. I do my 2 ADA Stark from date Ray. All right. So you do your little caption there, and then you get going. All right, and then you have an introduction. Then I do my 3 big headers: introduction, analysis because it's objective. You do argument if it's persuasive or if you're told to write an argument, and then conclusion. For an introduction, like I said earlier, you just literally draft, it's a regurgitation of what they told you to do in the task memo. So, so here I just said below, please find my analysis of whether any evidence of 3 specific incidents are admissible as substantive evidence, and whether any of the incidents are admissible for impeachment if Ms. Martin takes the stand. And a couple of like little things to note here. One, I deleted a little typo, but you see that like I actually don't have spell check turned on. And all of you that are practicing, you should turn spell check off. Because when it comes to the bar, like it's really distracting. And yes, there is spell check. You can run spell check when you're in ExamSoft, but you don't want to waste time. You don't want to waste time making sure that your PT looks perfect. The graders know that you're in an exam. They know you're in a timed environment. I'm a professor. Like I am, when it comes to practice, I am like the nitpickiest person out there. Like, you know, I am so picky, and everything has to be grammatically correct, perfect word choice, everything. The bar exam is not like that. The bar exam is all you're trying to do is write a decent first draft. That is it. So that's all you're doing. You have to remember that perfection is the enemy of completion. If you catch yourself, and I know a bunch of people do it because I watch people do it, but if you do that, then you've got to stop. You got to like not use your delete button over and over, and not sit here and correct stuff over and over. So remember that perfection is the enemy of completion. Turn spell check off. So I have my intro. It's basically just taken from my task memo. And then for my conclusion, I just say, thank you for allowing me to conduct this analysis for you. If I can be of further assistance on this or any other matter, please do not hesitate to let me know. That's it. So I just like, it doesn't have anything specific. I'm not coming to any conclusions. If I had time at the end, I would have a little bit of conclusion. I would add to it, but I just don't right now. I want to just, one of the most important things is that you finish the performance test. If you do not finish it, you are not going to pass it. So when you're running out of time, the last thing you want is to run out of time before you have drafted a little conclusion. That's why I just do it at the outset. I have a canned thing. I don't have to think about it. That way, no matter what, if you run out of time, you want it to be in the middle where it doesn't look like you ran out of time. Because you know that a bar grader spends like 2 minutes reading your answer. And so because of that, you've just got to be, you want them, if you run out of time, you want it to be somewhere where they hopefully won't notice it. If you're missing a full-blown section, like a conclusion, even though it's like not really worth much, if anything, you've got to give the appearance of completion. So that's why I do that. Okay, so after this, so we read the task memo. I actually want to figure out what these 3 similar incidents are, just to get a little bit of, just to have an understanding. So now the next thing that we do based on our process here, so we've done steps 1 and 2. So we've reviewed the task memo, we've set up the PT skeletal outline. We've done our introduction and our conclusion. So the next thing we're going to do is we're going to skim the file, and I want to look for what are these particular incidents. Somebody told me that they couldn't, that their email hadn't gone through. Somebody posted in the chat the link to the file, so you should grab that. So thank you to whoever posted that. All right, so the memorandum. So here's a summary of expected testimony. So I actually don't, this is 3 people testifying, and there's 1, 2, 3. So here, these are witnesses that have been subpoenaed, but I want to know what the incidents are. So this is just telling me expected testimony. So, but I look at this, there's Constance Gaynor, a customer service rep. So there was that one. Then there's Henry Franks. Franks is an accounts manager at Chiclets Clothing, a women's store. And I might just like highlight in here what I think are the important facts. So she reviewed a score for application from Bernicia Martinez. So I know that I'm looking for, so if it's character, then I'm looking for something that's going to be a similar act, right? So here there is an application and there's identity theft, right? That's the charge that we have here. So I'm looking for stuff that is similar. So similar for identity theft, and then also for anything that would show that could be used for impeachment, right? So showing truthfulness. Like, all right, so identity theft. So it looks like there's this, you know, you might have been pretending you were somebody else. Henry Franks. I'm not reading this in depth right now. That's why I'm going through it quickly. So Franks is an accounts manager at Chiclets Clothing, and he will testify that he received an application for store credit from Bernicia Martinez. So there's another application, and I'm assuming that here that this is actually the defendant. So the filing again for another card or another account, not using her name. So again, it's considered identity theft probably. So this is looking fairly similar. And then we have this third one here. Timmons was the Martin's immediate supervisor at Fastcom. She'll testify that Martin had a position in the accounts department. So this is somebody that's going to testify as to the defendant's ability to gain the information. So the defendant had a job where she would review applications for new accounts and provided applications including Social Security. So they're going to testify. So it's their immediate supervisor. So this doesn't tell me what the specific incidents are, though. It doesn't tell me the specific incidents necessarily. So I want to look for that. Okay, so I'm just going to skim through this, and really what I'm looking for is like numbers. So excuse me, or like first, second, third, I'm looking for a list. So I skim through this. Generally speaking, a skim is you're just looking kind of for stuff that stands out. So I know that I'm looking for specific instances here, and I know there's 3, so I'm looking for a list of 3. And we know that they were summarized in this hearing, in the transcript. So first, I'm referring to 3 separate incidents, so that's what I'm gonna look at. First, we have a good faith belief that 3 months ago, a police officer stopped Miss Martin for broken taillight and gave the officer a different name and driver's license than her own. So that's one incident, and it's 3 months ago. Hasn't been charged. Second, stopped Ms. Martin on the sidewalk outside the Blue Moon Bar about 2 months ago. She was drunk. Okay, so here's an incident of her being drunk outside a bar 2 months ago. Not a big deal. I mean, right. Third, we have information involving, well, it's not a big deal related to the identity theft. It's not similar. Third, we have information involving Bernicia Martinez, and whose name is Martin, tried to open several store accounts. So this goes to those incidents we have the expected testimony about. So this goes to that incident that we have testimony about. And the reason I want to point this out here is, so now I'm seeing I have this expected testimony from 3 witnesses. 2 of the witnesses are testifying about this 3rd incident. So what that tells me is that the 3rd incident is probably more important than the other 2. There's probably going to be more to talk about with that 3rd incident. So when I'm writing, I want to deal with the first 2 and get to this 3rd one. So like just as like me knowing the rules of evidence, generally speaking, the first one sounds similar enough that it might be admissible. The second one doesn't sound like it's going to be similar, so it should not be admitted as substantive evidence for sure. I don't think about as truthfulness, but maybe. Yeah, I don't think it will. So I don't think the second one's going to come in, but the 3rd one, they're giving us a lot of information from the file. So that tells me the 3rd issue is probably the biggest here. So when I'm triaging, I know that I've got to like hurry up on the first 2. Definitely, I think the second one is the least important. The first incident is probably the second most important, and the 3rd one is the most important. And that's something the bar examiners do. If you on this one spent a lot of time on the first and second incident, you would run out of time on the 3rd one and you wouldn't finish and you wouldn't pass it. So they are testing your time management. And sometimes they do that by giving you something that's more complicated later on to see if you actually managed your time well. All right. And then, okay, then there's some, I'm just skimming this to see what else, if anything stands out. Here they argue that they don't qualify under 404B. And we're arguing over 404 and 608, which makes sense because that's what was mentioned in the task memo. All right, and that's it from the file. That's it. So we're going to go back into that in more depth later, but the file is not that big here. So it's just a few documents, a summary of these expected testimony, and then the transcript. All right. All right, hang on 1 second. Any questions so far? Well, let's hold questions until the end. So here I have, I'm gonna make a note here in my analysis section that I have the 3 incidents. So, traffic stop, I have traffic stop, I have drunk stop, and then I have what is it? Bernicia, N-E-C-A, Bernicia Martinez. Okay, so I'm just gonna make some notes in here, and I'm just gonna say, to me, like, I might just make a couple of notes about the significance of this. Used different name, driver's license, drunk stop. There was nothing really significant about the drunk stop. She was just drunk. Officer walked away. There was no arrest on either of these incidences. And on this one, this one we have tried to open. numerous times. Okay. So do you guys all, so that's the file. So usually if I'm not talking through this would go pretty quickly. Here I spent a little bit more time in the file because I'm trying to identify what these incidents are. So then next thing I'm gonna do is I'm gonna go to the library. Give me 1 second so I can pull that up. Hang on 1 second. All right, now let me share my screen again. Okay, now the next thing we're gonna do, the next part of the process is we skim the file. Now we're gonna skim and read the library. Remember that we're reading each case with a purpose. We're trying to identify what the rules are and where I'm gonna draft a rule proof, what incidents. All right, okay, actually, let me give you guys, I'm gonna give you guys, let's say 15 minutes. I'm gonna give you guys 15 minutes to go through the library. So at 7:10, I'll stop. All right, that's 15. All right, so a couple of things. If you guys are reading, if you're using like Adobe to read, even with Adobe Pro, and I don't know about regular, but you can only highlight in one color, but in ExamSoft, you'll be able to use like 7 or 8 different colors. So this is what I've done, and I've assigned a color to each thing. So I used green for facts, I like highlighting like the start of a fact paragraph. And let me step back for a second. Generally speaking, the cases are IRAC'd. So you can know that, like, all right, they're gonna start with the issue at the beginning, and then they're gonna give you they do state the issue, then they do the facts, and then they give the rules, then they give the analysis, and then they give a conclusion. So here I want to know, what it was. I know this is going to be dealing with some of the same issues as my case, obviously. So I looked at this and I want to see what the holding of the case is. So here, the appellant claims that the trial court abused its discretion in admitting evidence of certain acts under Rule 404B. So this is dealing with 404, which is the first issue. Oh, here, actually, before I should have done this. So I want to identify, so first we have talking about character or admissible as substance. So I want to identify what my issues are, and then again, and this is for admissible, and I have my incidents. So let me just take a step back. So based on the task, I should have done this earlier, but I have my settings, my headings A and B, and then I have what the 3 incidents are that I have to analyze, whether they're admissible for their substance and admissible for impeachment. So I have each of those. So my analysis is essentially 2 major sections, and each one I have to analyze under the same issues, right? So admissibility for substance under 404B, and then admissibility for impeachment under 608, I think it is. So this first case is dealing with Landau. The first case is dealing with the first issue. So I'm going to just make a note of that here. And so actually, yeah, I'm going to make a note of that here. So all of you, we talked about this at the beginning, you guys all use like ERIAC or CREAC or CURPAC or whatever it was. So here, you're going to use that as well. So I actually make rule proof, analysis, counter-argument, conclusion. So I just make a quick note of what am I using each of these, or what cases I'm using for my rule and for my rule proof here. And then I'm going to do my analysis of each of the issues. So for here, the rule I'm probably going to pull is probably going to be 404, and I'm going to use Landau. So I think just based on reading this, but let's go through it a little bit. So here it says, in its case in chief, I skip the facts. I rarely read the facts. So just so you guys know that, I don't do it. One of the things that the bar examiners say is they're testing your time management. And can you discern what's relevant from what's irrelevant? I don't get too buried in the facts. The most important facts are going to be in the analysis that's in the case, or in the analysis section in the case that you get. Sometimes, occasionally you'll have to go back and check something in the facts, but you still haven't wasted any time because you're not spending too much time in the facts to begin with. So here it just says in its case in chief. So I label that as facts. I label those green. In his opening statement, Landau's counsel claimed that his client, okay, so that's facts. In response, that's facts. Okay, they're talking about they intend to offer evidence of 2 specific instances. And here I actually do want to look at this a little bit closer. It says first, it proffered evidence that 2 years before the events in this case during an application, Landau provided the bank with a false name. So all this stuff. So I just think it's significant because they're giving us these times. Then second, the prosecution proffered evidence that 1 year before the events in this case, Landau had been arrested for physically assaulting another patron of a bar after a heated fight. Okay, so 1 year before. The prosecution proposed to call both that patron and the arresting officer. So Landau objected to the use of both incidents, argued that they constituted specific instances of conduct offered to prove a person's character to show that on a particular occasion, the person acted in accordance with that character. That's classic character evidence, right? It's stated mildly differently, I think, from how the federal rules state it, or from how my evidence professor stated it. And so here we also know in the beginning that this court affirms the lower court. They permitted this, so the appeals court is permitting this evidence. So, and then I have, we first address the application for a mortgage. So they're going through the 2 different incidents. And then I highlight my rules in red. I highlight my rules in red. So I'm looking, okay, so it's got 404, it just states it, the rule here, continue stating rules here. And then we look for something, we look for the signpost for the analysis. In this case, and then here's the analysis, I use blue because I think azul. So I think in Spanish there, but so azul. So for the analysis of the issue. And then again, I have red and then I have the blue. That's the analysis of the case. And then again, I have red and then I have all the blue. You guys can do whatever colors you want. You can also just do like one word. It might be like a little jarring to read and like all highlighted. So for some people it is, it doesn't really bother me, but like actually after like going back and looking at this, after I did this earlier, I was like, whoa, at the color, especially at like the red. So, you know, but that's how you actually use some of the tools. So that you, like, I usually would like handwrite and pencil, like I would do like an R next to the rule, next to the paragraph. And like, I usually put my analysis in brackets. But since you don't have the materials printed out, you need to have some other method, and this is how I do it. So I highlight them. So here I'm like, all right, so all this talked about was 404. They don't get into the impeachment issue at all. So I'm using Landral for 404 for the admissibility of the substance. And then I want to look to see at my other case that I have. So here, Proctor, Supreme Court of Columbia, and then again, I just do facts. So facts, petitioner is charged with aggravated battery. So it's aggravated battery, and I just want to take note of what it is because I'm looking for 404 and 608. Again, it's facts. Prosecutor objected on the grounds that specific acts were inadmissible under 404. They talk about 404 and 608. So here, facts. Again, and really, I'm just like skimming the facts. I'm just really looking for like where do the rules start, because then it's going to get to the meat of the analysis. On appeal, the defendant argues that questioning the child witness about the shoplifting was a permissible form of impeachment. So they talk about impeachment. Okay, and then it gets to a rule. So it says, and you notice, like, you guys can tell when it's starting a rule paragraph, right? So like all these other ones that say the trial court agreed at this point on appeal, those are all telling you factual things. And then they start saying, you know, if a witness or our prior decisions have held, those are rules. So you want to identify what the rules are. So here it's like a lot of this is rules, and I'm really focusing on like what is rules and like what is explaining why those are the rules. So here we have, if a witness takes a stand and testifies, she puts her credibility in issue, that's a rule. Thus the opposing party is entitled to impeach the witness's credibility. And then it says under rule 608B, a witness may be asked about specific instances of conduct that are probative of a witness's character for truthfulness or untruthfulness. It says below that the rule does not explain how to determine if an act is probative of truthfulness. Like that's something I'm not going to include because it's just telling us what something isn't that isn't there. So next, I'm really highlighting the rules I think I want to use, not just all of the rules. Our prior decisions have held a wide variety of conduct to be probative of the witness's truthfulness. So here it's giving us samples of what is probative and then what is not probative. And then here, then it's going into a little bit of analysis, but it says this court has never considered whether an act of shoplifting is probative of truthfulness or untruthfulness. So they don't talk about shoplifting. A thorough review of federal, state and federal case law indicates that the law is not well settled. So they're going to give some history when the law is not well settled. And the history isn't really our law. I'm looking for what does the court adopt in this situation. It says a majority of federal courts and some state courts have held that acts of theft are not probative of truthfulness or do not involve dishonesty. In contrast, a number of courts have concluded that it is. So these cases can be grouped into 3 categories. So I want to see what this court holds. So I'm kind of going through it quickly. So they give the broad category, broad, middle, and narrow. So they tell you what the broad category is. And I might just highlight that so if I need to find it again, it's easy. Then we have, in contrast, the narrow approach. And I might just highlight that so it's easy to find. Requires the act to have an affirmative element of a false statement or deception, but they haven't defined the middle one, and so I'm thinking that that's what our court's going to do. It says the majority of federal courts take this view. We decline to follow these courts, however. So one thing, this is why also they're giving all this history, but then they say we decline to follow these courts. So I wouldn't want to, that's why I read everything before I start typing in my rules. Because here, had you just started typing assuming that those were the rules, you would have been wrong and you would have wasted a bunch of time. So you want to finish going through the library before you start writing in your rules. So we are most persuaded by the middle approach, which incorporates the narrow view, right? So it incorporates it. So I want to type in that narrow view, but also permits questioning about conduct that indicates a willingness to gain a personal advantage by dishonest means, including by taking from others in violation of their rights or by encouraging dishonest behavior in others. And then they give a sample. I like to highlight these case within a case. You can just pick a different color. Persuading, so in this other case, they held that persuading a witness to lie on the stand, that is suborning perjury, constituted a proper focus of questioning on cross-exam under Rule 608B. Then it says common experience suggests that, and when they say that, like they are stating a rule. A person who takes the property of another for her own benefit is acting in an untruthful or dishonest way. Such behavior reflects someone's truthfulness because a person who stole from another may be more inclined to obtain an advantage for herself by giving false testimony. So therefore, we hold that shoplifting is a specific instance of conduct that are probative of truthfulness. So we hold that the trial court abused its discretion in finding the defense counsel's question improper. So there they reversed. So here you can ask about shoplifting. And I don't think this one, none of the instances actually involve shoplifting. So you could say that trying to open an account in another person's name is getting at truthfulness, or it's kind of akin to shoplifting, but I don't think so. I mean, but we can make that argument. But this one, so now I want to do my, I'm going to do, let's see, so here, and all like a lot of what I'm trying to show you guys is like, how do you deal with the materials? And really it's with dealing within the library. I'm going to get into, I think I'll get into a little bit of the analysis this time. I didn't get into it in the last workshop because it was so much more time spent on the process, which we'll see how we get tonight. But we're trying to figure out to say, okay, well, you know, what am I using here and what am I not using? How am I using each case? Like, why did the bar examiners give me this case? So here we're going to use, it's going to be Rule 608. And then this case really doesn't get into 404, right? It really doesn't. They objected on those grounds, but it was admissible for, well, on appeal, actually really, so the evidence of shoplifting was inadmissible under Rule 404 for this one for a aggravated battery, but it wasn't similar enough. So there is that holding there. So you could use it for the first section too, but really what this case is, and like, I'll talk about that in a second, but really what this case is focused on is the impeachment part. And it makes sense, right? The first case goes to the first issue, the second case goes to the second issue. And that's often how the bar examiners do this. They'll give you, if you have 3 issues and 3 cases, 1 case will go to each, or there will be, you know, or there'll be sort of a mix, but that it's not uncommon to see this done this way. So I want to make a note here that it's 608 and that this is Proctor, I think, yeah. All right, does everybody see how I did that? Let me see it. Do you guys all see how I did that? Makes sense so far? Okay, cool. Good. All right. The next thing you're going to do, now we're done with the library, we're going to go to our next step, right? Which is actually drafting our rules and our rule proofs. So I've actually done it already. So I did it here. So for character evidence, and I keep my little headings in here, but I would delete these before I actually turned it in. But I just pulled my rules here from the Landau case. I pulled my rules here, and it's literally just the cases. It's just the rules that I highlighted. It's just the rules that I highlighted. And I basically take them and type them verbatim. I'm not in a persuasive PT. Sometimes you want to modify the way the rules are written to write them in a more persuasive way. But I just literally took the rules that are in here that I highlighted. So just prior bad acts are inadmissible to establish an individual's character or propensity to commit a crime. Prior bad acts are admissible for other purposes, such as, but not limited to. I added the but not limited to because they stated in a separate sentence that it's not exhaustive. Admissible for other purposes, such as, but not limited to, proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident, right? Which is just mirrors the federal rules. And then I cite that there. You could also cite to Landau. I just cite straight to the rule. To determine whether proffered evidence is relevant for one of the other purposes, the court considers the degree of similarity to the charged crime and the temporal relationship of other acts. So I know for each incident, I have to analyze how similar is it to the charged offense, and is it within the temporal relationships? Is it within the temporal relationship period? So I want to look for something, and I don't know what that relevant time period is. So I want to make sure that the case tells me what that time period is. So specific acts can serve as a basis for inferring the defendant had a mental state inconsistent with evidence. And then I write a case explanation or a rule explanation or a rule proof. And I follow that formula. So in case name, in Landau, the court held admission of a falsified mortgage application was properly admitted in a bad check passing scheme when the defendant claimed she did not know her co-conspirator's check would bounce, and defendant claimed she did not intend to defraud the bank because her false statement shows she intended to pass bad checks and absence of mistake. So I have the language from the rule in there. The court further held the prior bad acts were sufficiently similar. There's a typo here. Similar to satisfy the 404 requirement because lying on a mortgage application and passing a bad check both demonstrated willingness to deceive so as to secure money from a financial institution. The instances were sufficiently close in time when the fraudulent mortgage application was filed 2 years before the current offense. So I know if our instances are within 2 years, if they're less than 2 years, they're going to be within that temporal framework. And if you're willing to defraud a financial institution or defraud another person to gain a financial advantage, that it's going to be sufficiently similar. So then I'm going to look. So I have my rule and my rule proof here. And the way I organize this, I then have the 3 incidents that I'm going to analyze each incident and conclude regarding whether it's admissible character evidence. So I have the traffic stop, the Blue Moon Bar incident, and the Martinez incidents. Does that make sense? Do you guys all see how I did that? All right, and then I did the same for the next one. I just have my rules here. So if a witness takes a stand and testifies, she puts her credibility in issue, and the opposing party is entitled to impeach the witness's credibility, Proctor. And these are just all pulled from Proctor in what's read here. A witness may be asked about specific instances of conduct that are probative of a witness's character for truthfulness or untruthfulness. Columbia courts require the act to have an affirmative element about it, and this is just stating the narrow thing plus what they add, the middle road. So Columbia courts require the act to have an affirmative element about a false statement or deception, but permits questioning about conduct that indicates a willingness to gain a personal advantage by dishonest means, including by taking from others in violation of their rights or by encouraging dishonest behavior on others. Conduct that is probative of truthfulness includes providing false information to a police officer. We know that that's the first incident. Intentionally failing to file tax returns. We don't have that. And misrepresenting information to obtain a loan. So we have that too. That's identity fraud, right? So like pretending you're somebody else. Conduct that is not probative of truthfulness includes acts of violence, instances of drug use. So like drug use, we can say alcohol falls into that category. She was drunk, so that's not going to indicate truthfulness. Driving under the influence of drugs and bigamy. So those are all the instances. If you were running out of time, one thing you could do, just as like a heads up, is you can cut your rules. If you have lists and the lists clearly include things that don't apply to what we have here, you could strike them out. So like I could delete intentionally failing to file a tax return. I could also delete acts, well, she was yelling at a police officer, but she wasn't driving under the influence and there wasn't bigamy. So you could cut parts of those rules out. And then I would draft my case explanation of Proctor. So I actually want you guys to take a few minutes to do that, and then I'm going to show you mine. So take like, I don't know, let's say 7 minutes, let's say 5 minutes to draft what a case explanation will look like. And I'll put the formula back on the screen, which is right here. Can you guys still see it? The formula on the screen? Okay, because I changed it on mine. All right, that's been like 5 minutes. All right, this one's a little harder to write. I'm not gonna lie. I actually think the other one's easier, but this is all it is. So compare yours to mine. So I said in Proctor, the court held a shoplifting incident was admissible, right? All we're talking about is the admissibility for impeachment, admissible to impeach a witness, because shoplifting is an instance where a person is taking the property of another for her own benefit, which meant that the shoplifter was more inclined to obtain an advantage for herself by giving false testimony. That's it. I just pulled all of it. Actually, it's more of like what I identified it as a rule, but I really just pulled all of it from here because it says it's right before the conclusion. Therefore, we hold that shoplifting is a specific instance of conduct that is probative of truthfulness pursuant to Rule 608B. Did y'all get something basically similar to that or a similar thing? Good. Good. I see, well, the people that I can see, I see nodding, and that makes me very happy. Good. And then what you want to do, and one thing I want to point out here, right? You notice that the case explanation is just, or the rule of proof or rule explanation is just about what the heading is that's directly above it. It's just about impeachment. My rule of proof up here is properly admitted in a bank accusation. Was properly admitted, it should say, false murder was properly admitted under 404, oops, B in a bad check cashing scheme. So I'm talking specifically about the 404 requirements up here, right? That it's admissible as character. So do you guys all see that? So you want to keep these specific. So I often, like one of the mistakes that I see people make all the time when I'm reviewing PTs with people is that they, their rule proof is too broad. It's talking about, like if a case talks about multiple issues, they're talking about tons of issues, and you just got to keep it focused on what this issue is you're dealing with specifically under this heading. So this is character evidence. All right. So now, let's see. Okay, so next thing that you would do, is you would go through and you would read the file, right? I want to do a little bit. I'm going to just actually talk about it. And I'm going to do a little writing and demonstrate it, and then I'll let you guys do it, and then you can compare yours to the answer when I send that out, which I'll probably send out on Tuesday, just FYI. So you guys should try to finish this and write this, but I'll probably send out the answer on Tuesday. So what you have to do in your analysis is you've got to make explicit factual comparisons from our case to the present case. So let me open the file back up. So like this one. So a couple of things, right? In my analysis. So remember that, is it going to meet the two requirements of 404? So specifically, it has to be sufficiently similar, right? Is it sufficiently similar? And is it sufficiently close in time, right? So this one is also giving a different name and driver's license number. So that's sufficiently same, right? And it's 3 months ago. So that's definitely, the other one that was within 2 years was sufficiently close in time. So I'm just gonna say what you've got to do. So here I'm gonna analogize. So I'm analogizing to Landgraf, so under the traffic stop. So just as the defendant in Landgraf's, I'm just going to make an explicit factual comparison. So just as the defendant in Landgraf's, let's see, what did Landgraf do? Okay, let's do this. We're going to do this. Just as the falsified mortgage application was properly admitted to show under 404 to demonstrate intent, and what was it admissible for? A mistake in a false check cashing scheme. Miss Martin's giving the police officer, or was substantially similar. Giving the police officer a false name, a different name and also likely qualify. Substantial. Why is that? So it's substantially similar because in each instance, why, somebody tell me, Jose, why are these substantially similar? Sorry, you're my like student from class, so I'm gonna call on you. Everybody else, I'm like, they'll just hang up on me maybe. What's that?
Well, give me a second here.
Or does somebody else want to tell me?
Yeah, Proctor, right?
Yeah, no, this is Landau. Why is so in Landau, the falsified mortgage application? So there is a fake mortgage application, but they're both intended to get money, right? So how are these two similar?
Well, in Landau, the defendant there, defendant applied for the mortgage application and lied.
Yeah, okay, right. So they lied. But how are these similar? How are these instances similar, right? So like in one, right? So the falsifying a mortgage application is the same thing as giving a false check. Just both are instances trying to get money. Here, she's pretending to be someone else to avoid a penalty, right?
Right.
So here she's trying to pretend that she's somebody else to avoid a penalty, right? And then also, what is she being charged with is identity fraud. In this instance, she's also stealing somebody's identity to try to, I don't know, achieve some advantage. So in each instance, the defendant lied in order to gain a personal advantage,
which is what they're charging for on the
exactly.
On our case, right? Okay.
Yeah, exactly. Yeah, good job, Jose. Yeah, exactly. So I'm gonna try to show that these are very similar. And then I've got to talk about the temporal piece. Additionally, the instance here is 3 months. I'm not going to say merely. I would do that if it was persuasive, but I don't want to use that language because it's objective. Occurred 3 months ago, which satisfies the temporal because the court found an instance that occurred 2 years earlier was
the first instance,
was sufficient was sufficiently close. Yeah. So then what's my conclusion, right? My conclusion should be regarding whether it's admissible under 404. Thus, just as the court in Landau admitted the statement, properly admitted the statement, because that's what the appellate court said. This court will likely find that the incident of is admissible for its substance. So then I have a quick conclusion there. Does that make sense?
Mm.
So you compare the facts and the like facts and demonstrate the similarity, because I'm analogizing under the first one. And then I state my conclusion. And in my conclusion, I'm also showing how it's similar, because I'm trying to place everything within the context of the other courts. Everything within the context of what the other courts did. Nothing is my opinion, right? This is saying that this is what the other cases dictate what must occur here. And then you just do that 5 more times, you know, for the Blue Moon Bar incident, which we know is going to be inadmissible for its substance. The Martinez incident, this is really where the points are. And then we go through and we do it regarding impeachment for the same 3 incidents. And I will tell you that I looked at so obviously I looked at the selected answers. I actually did all of this and wrote it before I looked at the selected answers. And mine looks almost identical to the selected answers. The selected answers, though, are they're longer. And what I am trying to do with you guys, and what I try to do when I'm teaching, for the most part, is show you what will you get, what do you need to do to obtain at least a 65, and usually like a 70, sometimes 75. So and like here, I will tell you, I'm trying to deal with traffic stop and Blue Moon Bar quickly because I know those points are in that third one because there's so much testimony surrounding the Bernicia Martinez incidents. So I'm trying to deal with 1 and 2 quickly on each of these. Does that make sense? So I'll tell you guys, somebody emailed me and they specifically asked, so I'll tell you guys, this is the last of these like free workshops I'm gonna do because they're a ton of work to prep for. And I've got my courses that I have to prep for, but I am doing a whole course and it's a special price. I lowered it from what our normal one is. And it's a series of workshops. So it's gonna be all of the California PTs that are 90 minutes plus. So it's 5 Saturday mornings. And then I'm also gonna do a Monday evening version for people that like don't want to do a Saturday morning or don't want to give that up. So there'll be a Monday morning or Monday evening one as well. And we'll go through, so I'll go through in-depth writing analysis. We'll go through like a bunch of them. So we'll go through doing the whole analysis, the whole process, like samples. I'm going to go through if you have to write a letter or a memo or a brief or a letter to opposing counsel or a letter to your client. All of those different things. If you have to draft a closing argument, what should everything look like? So I'll give you like template structures for that. And then I'm going to do, so that's the first one. The second one is dealing with a bunch of objective PT. So I'll have a few of them. All of them will have model answers too, so you can do a comparison. The third one is persuasive. The fourth class is like other tasks. So like like the common ones are a letter, a brief, a memo, stuff that's really common. And then after that, so I do oddball tasks or like other tasks. And then the last workshop is worst case scenarios. So like, what do you do if you're told to draft a will, right? They did that on the UBE in 1999. That one, if you have to draft a closing argument, they actually just did that in the UBE. So I had a bunch of students take New York and they had to draft a closing argument. One person who took it and didn't pass, I'm tutoring her now. She was like, it was a closing argument, so she did the wrong thing. And that's why she didn't pass it. But so what, what do you do if you have to do all of those things? So we'll go through in depth to like really kind of distill down like how to take a PT, because like I said earlier today, you really want to be able to like, you want to know, as you're going through it, because this will be the last thing you do and you're probably gonna feel terrible, right? Like when you take the bar exam, like it doesn't feel good. Like, I mean, I cried. I'm like not an emotional person. I'm like classic defense lawyer. And I like at lunch I started crying after mine was 3 days. So cried at lunch, cried afterwards, cried during the MBE, well, like at lunch and afterwards. And then on day 3, and I just like ate my weight in burritos to suppress all of it. But the classes start at 9 a.m. on Saturdays and they start at 6. They're each about 3 hours. The first one might go a little bit longer, but hopefully not. Yeah. So just so you guys know, I'm doing that. And they start, the one on Saturday starts on the 8th. The following one is, I think, on the 17th on the Monday. The second series, I've had so many people like responding to it. So that's why I added a second series of classes. And then all of them will be recorded. You'll have access to them later as well. So if there's something that you want to go back and review, you can go back and review it. And then you'll obviously have like all of my model answers. And like, I'm going to do it where I post like, where I actually give you the answer with my entire process. You can see, okay, after step 1, this is where I was. At step 2, this is where I was. So you can look at your process. And one of the biggest things, like I've been teaching bar prep for a while now. And one of the biggest things I see is that people make errors in their self-assessment. They can't figure out where exactly they went wrong. So I'm trying to show you the process of like what you should have figured out at which points. So that you can utilize that in your assessment. It doesn't include grading or anything, but I think it's sufficiently, there's a lot in it to really help you out with that. And then yeah. And it's lower. It's usually, I usually have a class at $650 and this one's $499. So yeah, so it's less than I normally charge and a lot less than my full course. So any questions about anything?
Yeah, I have a question.
Yeah.
You're doing a Saturday one and then you're doing a Monday evening one?
Yeah.
And they're 2 different sessions?
It's the same class, just 2 different times. Because like for some people, mornings on Saturdays are better, like if you work or whatever. But some people, it's like they would prefer to do an evening. And like sometimes like my mornings are super, like that's when I do my hardest work. So, or like that's when my brain is best. So sometimes I might want to do a class where I'm not going to be first required, like where I'm not going to be required to be like hyper focused. I like to do that later. So
let's say we signed up for the morning one. Can we switch back and forth, or are we set on one?
You could, but they're staggered. They start at different times. So like the Saturday morning one starts the 8th, and then the second one I think starts the 17th. If it starts the Monday.
In other words, if we sign up for the morning, are we able to log into the evening ones, or and vice versa, or are we just...
Yeah, you absolutely can. You absolutely can. Just like you'd want to just talk to me first. Here, I'll post the link for it. Hold on. And I'll send this out. Like I'll send the everything out. The second, I will tell you, there's a typo in it. I didn't.
And I think you said they were going to be recorded, so we could always review it, right?
Yeah, exactly. And here's there's a link to the course. And but the selected dates, the one on the 17th, I've just added it, and my web guy has been on vacation, so he's gonna fix it, I think, in the next day or two. So there'll be options. So, yeah.
And we have access to the classes up until the bar date. Is that the way it works?
Yeah. Yep. Yeah. Up until everything cuts off on the 6th.
Got it.
At like 11:59 p.m. Not that like afterwards you're gonna want to look at it, and you shouldn't, because that's just awful. Like,
Great.
Don't put yourself through that.
Awesome.
Yeah. Yep. So there's that. And yeah, I'll post this. This video is going to go up on YouTube. So if there's anything that you missed, I also, if you guys want, if you didn't hear me earlier, if you can just like in the chat, send me your email address. I do a like a blog post every week. I've been doing, and so you get on our newsletter. So I obviously have read, like, I feel like every bar like advice thing out there. So I try to include stuff like tips that you won't have seen other places. So I've been doing a series of MBE tips each week. So I've done, I think 4 or 5 subjects. I think crim law just went, that was the 5th. So I have 2 more. And then I'm going to do a series of essay specific tests, like test tips. So for subject specific essay tips rather. So those will be going up, and then a whole bunch of stuff. Oh, I sent the link only to one person privately. Sorry about that. How do I do it to everyone? Oh my gosh, I keep just sending it to the same person who I think is already in the course. Hold on. Oh wait. Oh, there it is. It wasn't showing me that. There it is. But so if you guys also in the chat message me, and that way I can add you to the little newsletter. It's really, and like I send out 1 email a week. It's not a ton, although I will send out a little bit more this week with this stuff, with this material from tonight. Yeah.
Professor Marine, thank you so much for the class. Can you hear me?
Yeah, I can. Oh, thank you. Yeah, you're welcome.
Thank you. I mean, my friend Marissa took your course. She
yeah.
Yeah, she said she wouldn't have passed the second time without taking your class. So I think it's great. I just have a quick question, if it's okay to ask you about the essay.
Sure.
So the task memo talks about, you need to address 2 issues. The first one is whether she can, whether these 3 specific incidents can be admitted as substantive evidence. So when I was, before your class, I purposefully just look through the library, see if I would be able to find any rules. And I specifically look for the keyword of substantive evidence. Actually, not one word in the library says substantive. Yeah. So could you point me to somewhere in the library that at least it hinted? Because I keep looking back and forth. I just couldn't never,
Sure.
Thank you.
Yeah, let me share my screen again. So it's in Landau. So and this is actually, and after this, I'm going to talk about an MBE thing with evidence that'll probably help you with evidence specifically. So it's really, let's see, let's look back at the task memo. It says here, I would like to admit them as substantive evidence under Rule 404.
Oh, okay.
So it's there that it gives you that connection, right?
Oh, okay. So if I find a 404, I know that that's the key for the...
Exactly. The other thing on top of that, so regarding MBE, so one of the reasons I know like 608 and 404 is because you often see those tested together on evidence MBE questions. Right. And so it'll give you like, 4 answer options. it'll give you 4 answer options, and one will say, you know, inadmissible, admissible for its substance, admissible for its impeachment purposes, or admissible for both. And that's because these things are often tested together. So you have to run through both full analyses. Like, is it character evidence, or is it one of those other bases where it's admissible non-character, right? You're not offering it to show action and conformity therewith. Or is it impeachment, and is it impeachment, and is it proper impeachment? So like knowing that, like, is it admissible for its substance is always, generally it's asking you of character evidence. You have to come up with a non-character purpose for it. That's how you get it in under its substance. So being able to read and like understand what's going on factually in the case, and then obviously knowing the difference between civil and criminal for evidence MBE questions, you'll see that a lot. So you should look at, I don't know if you have any issues with evidence questions at all, but like, I remember when I've like figured that out on evidence questions, like, why is it, like, what's the distinction between these things? It was really telling me like it was really doing a 404 608 comparison. Does that make sense? Ying?
Yes, thank you.
Yeah. So for any of you guys that like see those questions and miss those questions, you like, I had to create a little table, which I don't know that I still have. I probably do, but create a little table of like 404, and it's really just there's a mnemonic, right? For, is it mimic, motive, intent, mistake, absence of mistake or fraud, and then common plan or scheme. So mimic, or Miami cops is another one I've heard, which I think is a little bit more, but yeah, so like those are the mnemonics. So ask yourself, okay, well, if it's admissible for a substance, if it falls into any of those categories, otherwise it's not, but it can still be admissible for impeachment purposes only. Or you can have it admissible as both impeachment and substance, or it might be entirely inadmissible. So those questions, which you will absolutely see at least like 2 of on the bar, on the MB, well, maybe 1, since it's only 100 questions this time, but yeah.
Hey, Professor Moran, I have a question. I don't know if this is like stupid or not, but should we mention hearsay in this essay at all?
No, absolutely not, because they don't ask you about it at all.
Right. So, right.
Yeah, if you wrote about hearsay, you would just be giving them a reason to give you 55 and go to the next essay in 30 seconds.
That's what I was thinking. It seems like, you know, that the letter from the supervising attorney didn't really talk about hearsay, but I was just wondering about the 3rd incident where it was a reported telephone conversation and all.
Right.
But I guess if you're talking about exclusion and not exclusion, then you're dealing with hearsay anyway.
Yeah. So the only thing you could say, so like if you see that, which is good, right? If you see that, then at the very end, you can be like, you know, below, or, you know, it's established above, this will be admissible, this will be admissible, this will not be, or whatever. You might give your overall, you'd add to your conclusions. You could also say, additionally, you know, although you did not ask me about this, there may be some hearsay issues, which I would be glad to look into if you would like. Something like you could add a little thing, be like, yo, I saw this little hearsay issue, I'm so good, right? You could do something like that, but they don't give you anything. Like there's nothing in the library dealing with hearsay, but you could mention something like that, but like, and like you'll see on UBE ones, the point sheets that they give out, they tell you like, oh, a particularly astute candidate or applicant would have pointed out ABC, right? But like that, you've got to do everything else first. But if you do everything else and you like see that little thing, then like put that in the conclusion. Just like a little nugget there.
Professor?
Yeah.
How do you feel about reviewing or practicing the older PTs?
I don't think it's a good idea.
Okay.
I mean, like, I really don't. Okay, so a couple of reasons. It's just like, you can do 2. I mean, there are some that are worth doing. I will say that. There are some where they give you 2 tasks, but otherwise it's just not worth it.
Okay.
Because you're going to spend so much time. The other reason is you have, I don't know, you have like 5 or 6 or 7 of the California ones to practice from now. So 2 I've done in workshops, and anybody else that's doing the course will do every single one. But there's also 5 years worth or 20 UBE 90-minute PTs you can do that are free, all online. So they're on the NCBE website. So you can use those too. And I advise people to, you just literally do a Google search for NCBE and yeah.
Okay. Just because I was looking for the, you know, like other ones that they don't test frequently, like the closing arguments or, you know, like or a contract or something like that they've done before.
Yeah, no, I mean, that's a good, I would just go through, and I don't know off the top of my head, but I would just go through the NCBE ones that are available. You can also see, like the February 2020 UBE, and I think Minnesota might publish them, although I'm fairly sure it's a breach of a license, but I think it's them and Georgia maybe post the UBE materials. There's two states that do, but you can look at those most recently posted ones. But the NCBE, they only give you summaries of the last 5 years. They don't give you the actual materials.
Oh, okay.
You have to pay for them.
Oh, okay. All right, great. Thank you.
Yeah, and like in my thing, I do give a bunch of those out. Like I have a will, I have a contract, I have a closing argument, like I have all of those things. So yeah, and
Okay,
also
perfect.
like the only one, there's that. I can't think of any off the top of my head that are California ones that are like 2 that would be worth doing. So yeah,
Okay.
yeah, sorry about that.
It's okay. Thank you.
Yeah.
Yes, Professor.
Yeah.
Yes. Hello. Thank you so very much for this tonight.
Sure.
Any tips that you have for attorneys that are working and trying to understand all of this to a certain extent? Because I am a repeater, and I know part of it is a mental block. What I do daily is not what they're asking for, even though they say you're taking the attorney's exam. And so a lot of times I'm thinking what I normally do, sometimes less is more as attorneys, because we kind of know going back and forth. How do we get over those kind of hurdles?
Yeah, that's a good question. And I deal with that a lot. And I'm happy to talk with you a little bit more specifically, do like a little free consult thing and talk about some of your specific stuff. But like generally what I will say is, like, if something is triggered by the facts, you have to talk about it. Like if you see facts that show that there was if it's a burglary, right? If it's a burglary, or no, it's not a burglary. If it's an assault, but there's something that where, somebody, you were turned around, but I tried to punch you, right? But you didn't see it, right? But I tried to. There's all these facts that suggest that are like screaming, talk about assault, but you're like in your head, you're like, but I know there's not going to be a liability for assault, so I don't want to waste, like if you would not talk about it just because it'd be a waste of your client's money, you still got to talk about it on the bar. If you're going through and doing an analysis in your head and you're like, yes, no, okay, but I'm going to conclude that like that's not a viable claim, you still got to talk about it for the bar. If that helps you like in determining like what to talk about, what not to talk about, so that's kind of like my rule of thumb. And you know that the attorney exam is 2 days now, right?
Yes.
Okay, good. Yeah, that threw a lot of people off, and that sucks.
So what do we do in the morning? We just don't show up in the morning and then come in after the MBE?
Yeah, they'll give you specific instructions, so I would wait for those specific instructions. Yeah.
All right, thank you.
Yeah, of course. Anything else? Anybody else?
Yeah.
Yeah, I'm sorry. Well, go ahead, Robert.
Oh, okay. Earlier you were showing us how you highlighted in different colors and you said that's available in ExamSoft.
Yeah.
Is that available now, or are we waiting for like the practice download?
I think you're waiting for the practice download. And I wouldn't practice, even if you can in ExamSoft do anything, I wouldn't practice in ExamSoft. I would practice in Word. And I can show you guys what I use. I have a Mac, and I think on Word or on PCs, like the documents automatically will like snap to each side and like just show half of it or whatever. I use an app called the Better Snap tool. And that way I can like make my documents like basically split the screen with my 2 documents. So they fill up the screen, but it's called Better Snap. It's like $5 and I've like used it for years. I swear I would not function. I like lose my mind when I restart my computer and it's not on. So I use that all the time, and that'll help you with the side-by-side thing as well. I don't think that answered your, wait, what was your question though? I don't think I answered. Oh, so, but practice in Microsoft Word and like I always have my fact pattern on the left, because like I go through and like I write answers under time conditions too. So like I put my fact pattern on the left and my Word document on the right, and like that's how I do it. So like get in a rhythm. And soon, and I know like I'm in all the Facebook groups, and somebody in the baby bar group like posted a screenshot of what it will look like. So I think there's a way to tile it. I think you can do like a top bottom or a side to side. So look for that photo. Yeah. And then, yeah, that's how I do it. And then, yeah, I actually, I have Adobe Pro, and that's how I'm able, like I convert the PDFs to Word documents so that I can highlight them. So you can download a trial for like 30 days or 14 days or something. And then you could like pay for the subscription for like 1 month, and it's like pretty cheap.
Okay, thank you.
Yeah. That's how you can highlight in colors. Yeah.
I have a really quick question. So what's, is there any suggestions for the MBE online? Do you suggest us practicing without paper, just to do, you know, or?
I would practice online. Yeah, I would practice online, and you're not going to be able to mark up the questions in the like ExamSoft or whatever it is, I don't think. I actually, I'm going to do a post on that. I'm convening and actually part of a big panel discussion this Thursday with a bunch of other people that are like academic success and bar prep professors. We're all doing a panel this Thursday. And we're going to talk about tons of different stuff about it being an online test. And I'm not sponsoring it, so or else I would like invite everybody to do that. But based on all of that and the helpful information, I'm going to send out, if you're signed up for my newsletter, I'm going to send out a post with really specific tips regarding the MBE and, you know, essays as well. So I will do that too. So yeah, I would just say, like, no matter what, like, practice doing them now, practice doing them that way. And one tip for doing MBEs online and just doing MBEs generally, like, I'm a really fast reader. And one of the problems is that the MBE, like, I don't know if you guys know how much money goes into writing them, but it takes how much money and time. And they're really complicated. The reason they're so hard is they're written by a minimum of 5 subject matter experts, 5. So it's like your 5 property professors that are all like your worst nightmare got together and decided to write a horrific question, and that's what they're going to give you, right? And the answer options. And then they're tested for years on applicants. So like you guys are, well, I don't think you're actually going to have test questions on the MBE this time, right? So you cannot read these questions quickly. You have got to track them and like understand them as you read them. So one thing you can do that I do when I'm reading something online is I read it out loud in my head. So I, you know, like that way it forces me to slow down when I'm reading it, and I place emphasis on it like I would if I, you know, so I place different emphasis on it, not like, we know, and there's research that shows that like when things are on paper, we read it slowly and more intentionally, and you've got to force your brain to do that when it's on the screen. So practice doing that. So read it out loud in your head though, because it's recording you, and you don't want to be flagged as if you are actually talking out loud, even though you're in a room by yourself, right? It's still good, I would say, to still do it so they don't think you're talking to somebody else. Because you can move your lips, but it's different when you're moving your lips or like doing it in your head compared to like actually speaking. So.
Hey, Professor, so we're not allowed, so the ExamSoft won't allow us to highlight the facts on the MBE?
I don't think so. And it's not that ExamSoft won't. I think that the NCBE isn't letting us. Yeah, I think. And like, we'll watch for an update on that. But from what I can recall is you will not be able to do that. And it's answered on the FAQs. And I think in there they say no, but like I could be incorrect there. So double check that, but it's on the FAQs. And the FAQs are being updated all the time. So they're being updated, which is super fun for all of us. So yeah, we're all in this boat. I mean, like, I feel for you guys. But I will say, I do think, I mean, I know that not everybody has, and one thing that I know that California Supreme Court and the California Bar is considering, so I'm a professor at a law school, and they initially said that if we allow students to use our space, that we cannot put more than 1 student into a classroom, even though we have really big classrooms, and you could have like 2 people on opposite ends going out separate doors, right? Like you could really do it in a responsible way. And we're not allowed to have a proctor in the room either. But they're reconsidering that. They're reconsidering letting, 1 or 2 or 3 people in a room. So I know like Jose, the deans, and like we were talking about this at our faculty meeting a few days ago. So reach out to your law schools. If you don't have a good place to take the test, reach out to your law school and see if they're able to help you. And especially because those rules are potentially being modified. Yeah. And then Jose, what was your original question? Sorry, this is.
No, just saying that you answered it. That we can highlight on the MBE.
Oh yeah. So check the FAQs. Check the FAQs.
I've been doing it at the bar, and I've been practicing highlighting. So I guess.
Yeah, they have it because well, and even when you take the MBE in person, you're not allowed to have a highlighter. Like they only let you bring in a pencil on those days.
Yeah.
So but the thing I was saying though is like, I know that taking the exam this time sucks, right? Like I get, like it sucks. I feel for everybody. But when I took the test, it was in person. There were like 1,000 people in the room. And when everybody started typing, it was like a hailstorm, like no joke. I felt like I was in a tin shed and there was like golf ball size hail hitting. It was just like so distracting. I'm already a stress ball and like anxiety ridden. And then when everybody starts typing, when I'm like, oh my God, I haven't even gotten through the first sentence and people start typing already, I'm like, what is going on here? It was just like, it was so stressful. So I don't know, being able to like control your exam environment is kind of nice to an extent. Also check too, if you are looking for another place to take it, law school's like, I'm offering up my office. Like there's nothing in it because our school just moved. So like, you know, and like professors just have to like put like a sheet over like books or, you know, bookshelves and stuff like that. So like a bunch of us, I think, are offering up our offices for students to use. So check with your school if you want a different place to take it. Yeah, check with your school.
Oh, Professor, I just want to ask about typing speed. Like, you know, so many things you feel like you're under the gun to type really, really fast.
Sure,
and I was noticing that when you were typing this, you seem to be typing at a very nice, thoughtful pace. I wonder if that is a realistic pace to use during the exam?
Yeah, absolutely. So people ask about like word count and stuff. So, and like I can type at like 100 words a minute, right? Like I don't type that fast here, but like if we say, okay, so I generally think when I'm writing a model answer for something, I expect somebody to be able to do 75% of what I do. And to be able to score really well doing that. And I have seen, right, I'm doing bar prep and I run programs for repeaters. So I've looked at tons of people's essays that have failed. And I cannot tell you, not saying that this is the norm, but I have seen tons of essays they get an 80 that are like 800 to 1,000 words. If you type and I generally think that you can hit the issues in a bar essay if you can type like 1,200 words. If you spend 20 minutes planning your answer, which is what you ought to be doing. And I go through like a whole process of like how to do that for every subject and all of that. But if you do that, then you have 40 minutes left, right? 40 minutes, an average, like when I'm teaching and probably typing at more like a 40 word a minute speed, right? Which is like a nice pace. That's 1,600 words, right? You don't have to type that fast to be able to get to write a strong answer. Selected answers, the ones that are selected by the California bar examiners, they average, when we looked a couple years ago at like, did a whole analysis of all of them, they're on average like 2,700 words. Those are not attainable, right? Like it's a joke to look at them. Like you're just like, how am I supposed to do this? Right? And you don't know the rest. Like I remember like, I would get mad. I'd be like, I'm like, what is this nonsense? Or like, I would look at like the model answer written by my bar prep company. I'm like, I can't do this. Like I failed myself on every single thing. That is not the goal, right? That is not the goal. That's why like bar essays is good. Baressays.com is good. It's because like you can see what a 65 is. And like, that's what helped me keep my sanity when I studied for the bar was that, although it's, you know, it's a paid service, but yeah, I would say if you're hitting all the issues, right? You have to hit all of the major issues to pass an essay, right? And then you have to like properly analyze, use all the facts, all of that, have at least 2 counter arguments per essay that are in the right spot, like you have the right counter arguments, right? Not just like straw man arguments. If you do all of that, you can usually do it in around 1,200 words. And that's not even typing at 40 words a minute. So like don't, I wouldn't worry too much about that. But yeah, typing speed is like, it's an issue and I get that. And if you are like fairly, like if you don't type quickly at all, it is something to work on. Like it's something to work on. I have my dad, I'm trying to teach, like my dad had a stroke. So I'm trying to get him to type and I'm like just having him do typing games to try to like improve his speed. So otherwise it's just me sitting there and I like, you know, I'm like, here, do this game, Dad. Yeah. Anything else?
Yeah, I had a question about like the surveillance they're talking about going on.
Oh yeah, I have no idea. I will tell you that.
I mean, it just seems crazy. Like if my cat walks in, you know, is that a violation? I mean, it just seems kind of like a really weird way to add more stress to people.
Yeah, but it's like, you know, when you're being proctored, you're being surveilled the entire time.
But they were talking about using like artificial intelligence and then recording it, and then the artificial intelligence is going to review what I did during the exam.
Yeah,
that doesn't seem like proctoring.
It's been going on for a long time. They've done this with medical board exams. Like it's not new technology for testing. So,
All right.
and like, so the efficacy of it has been tested. So I wouldn't, you know, I know there are unknowns and that's scary, but, and I don't, you know, I don't know. I just know that this has been done for a long time.
All right.
Yeah. And the ACLU is fighting it. I can tell you that too. As soon as they announced that, they filed a motion to stop the use
Yeah.
of AI.
I believe it.
Yeah. Anything else? No, Jose, you're still smiling, so that makes me feel good. You're not like crying at the end of this. You're like, oh my God.
Got to get a poker face.
Yeah. No. All right. Well, if nobody has any other questions, then we'll go from there. But yeah, thanks to everybody.
it.
Yeah. And if you guys have any questions, shoot me
Thank
an
you
email.
so much. I appreciate
All
it.
right. Yeah, of course. Have a good night.
Have a good night.
Yeah.